Jane Moss, the owner of the East Grand Forks Bar and Grill, who defied Governor Walz's executive shutdown order last week, got her day in court on this Friday afternoon. The judge was here in Polk County District Court. Everyone else participated via Zoom conference.
I just want to tell you at the front end, because I haven't had an opportunity to fully review all the briefing, that it would be my intent to issue a brief order today extending the temporary restraining order until I can issue a full opinion in this matter. I don't want there to be any question about what's happening, but I also don't want you to think that if I file a brief order tonight that I've made a decision. I just want to make sure that the record is clear about the status of that restraining order pending my final or my written order with respect to this. And so, these are really considerable issues. And again, you've done a great job briefing them, but I won't be announcing a decision at the end of today's oral arguments. And I want to be clear on the status going forward. With that, Mr. Plegancool, I'm going to turn to you first for your oral argument on behalf of the state of Minnesota.
Thank you, Your Honor, and may it please the court. Minnesota, including Polk County, is currently being ravaged by the COVID-19 pandemic. In November and December, Minnesota has been sadly recording record numbers of new positive cases, hospitalizations, ICU admissions, and deaths. Just a few days ago, on December 16th, Minnesota reported one of the highest daily death reports during the pandemic, reporting that 92 individuals had died from the virus. Across the country, over 300,000 people have died. Polk County has not been immune from this deadly virus. In Polk County, as of today, over 3,000 people have tested positive and 43 people have died. There is no dispute that COVID-19 is a highly transmissible and deadly disease that threatens the health and safety of Minnesotans. Through its contact tracing efforts, data tracking, and study of the scientific literature, the Minnesota Department of Health has been able to identify settings, which include bars and restaurants, that present high levels of risk and are far more likely to result in the easy transmission of COVID-19. As epidemiologist Richard Danilla's affidavit states, MDH's contact tracing investigations show that apart from long-term care facilities, bars and restaurants, as well as the other settings that were required to temporarily close to the public under Executive Order 2099, are most frequently associated with COVID-19 outbreaks in Minnesota. As Dr. Danilla explains, bars and restaurants pose an extremely high risk for COVID-19 transmission because they allow people from different households to congregate together for extended periods of time in close proximity to one another and eat and drink and often talk without face coverings for extended periods of interaction. In fact, one study Dr. Danilla cites showed that an infectious individual transmitted COVID-19 to at least 18 other persons at a bar in the course of a single night. And only 4 of those 18 individuals reported even being in close contact with that individual at the bar. And MDH has already determined through its own investigation that at least 448 COVID-19 outbreaks have occurred at Minnesota bars and restaurants. MDH has tied at least 4,145 unique positive COVID-19 cases to these outbreaks. And Dr. Danilla explains in his affidavit that this is just the tip of the iceberg. Those were the direct transmission cases that MDH was able to tie. And there are likely very many more secondary transmission cases resulting from those outbreaks. Equipped with this scientific information and data, the governor issued Executive Order 2099, which made the difficult yet rational policy decisions to temporarily restrict conduct at the highest risk areas for COVID-19 transmission known to the state. And that included temporarily prohibiting on-premises dining at Minnesota bars and restaurants through December 18th, 2020. Importantly, Executive Order 2099 allows and encourages bars to continue to provide to-go and takeout services. The governor also recently issued Executive Order 20-103, which extended these indoor on-premises dining restrictions through January 10th, 2021. But it continues to encourage to-go and takeout services, and also permits outdoor on-premises consumption of food and beverages if COVID-19 safety protocols are followed. That includes 6 feet of social distancing, 50% capacity not to exceed 100 people, no more than 4 customers per table, and requiring the establishments to close by 10 p.m. It's undisputed that Executive Order 2099 has a legitimate goal of slowing and preventing the spread of the deadly COVID-19 virus. Despite the COVID-19 pandemic, defendant opened its bar restaurant to on-premises dining on December 9th, 2020, and despite repeated warnings, continued to provide on-premises dining to customers, necessitating the state to bring this action to civilly enforce Executive Order 2099 and to seek emergency injunctive relief, which the court correctly granted on December 11th. Today, with the state's argument, I want to address 2 main issues. First, I'd like to briefly touch on the correct standard applicable to granting the state's TRO and temporary injunction request. And then second, I'd like to focus on the 3 constitutional arguments that defendant has raised in opposition, in its opposition papers, which are separation of powers, equal protection, and taking. So first, just to briefly touch on the appropriate standard. The Court of Appeals in Cross Country Bank, which we cite in our opening memorandum, and I believe also in our reply, recognized that because Section 8.31 explicitly authorizes the Attorney General to obtain injunctive relief to enjoin unlawful business practices, the Attorney General, in that case, was seeking a temporary injunction, did not need to make a showing under the Dahlberg factors. Also, in State of Minnesota School of Business, and that citation is 899 West 2nd, 467, the Minnesota Supreme Court similarly recognized that the state is entitled to a statutory injunction under Section 8.31, meaning there was need to analyze the Dahlberg factors. As we explained in our reply brief, in this case, Executive Order 2099, which has the full force and effect of law during the peacetime emergency, makes bar, restaurant providing on-premises dining temporarily an unlawful business practice. Thus, the Attorney General can obtain a temporary injunction via its statutory enforcement authority under Section 8.31. And the District Court correctly applied that analysis when it granted the TRO. So that is the correct analysis. But in any event, the state has also briefed the Dahlberg factors. It briefed them in its opening memorandum and addressed them again on reply. And the state has explained that it is equally entitled to the same temporary injunctive relief under the Dahlberg factors as it is under the statutory injunction standard. So unless there's any questions about that, I'd like to next turn then to the defendant's constitutional arguments.
Go ahead.
And again, these constitutional arguments today essentially relate to the likelihood of success on the merits standard under the Dahlberg factors. So taking defendants' arguments one at a time, the first being separation of powers. As Exhibit 1 to the affidavit I submitted, that was the Free Minnesota Small Business Coalition case. This same separation of powers, non-delegation issue was raised. It was extensively analyzed by the court and rejected. And I would submit that the court should find that case to be extremely persuasive with respect to this argument being raised by defendants here. In that case, a coalition of small businesses, which included restaurants, argued that the governor's executive orders temporarily closing them for on-premises dining earlier in the summer or spring violated the separation of power principles of non-delegation. And the Ramsey County District Court conducted an extensive analysis and rejected that argument. The court noted the Lee v. DeMont case, which provides that the legislature may delegate power when it provides a reasonably clear policy or standard of action, and that policy or standard can be expressed in very broad and general terms. Here, Chapter 12 which is the Emergency Management Act, does not violate separation of power principles because it made the basic policy choices that provided adequate standards to guide and restrain the governor's emergency powers. For example, it prescribes 6 specific conditions for when an emergency can be invoked. It prescribes and establishes a time period for the governor's exercise of specific duties. It requires review and approval by the executive council, so all the other independently elected constitutional officers in the state. And it gives the legislature the ability to override the governor's declaration, whether it is in or out of session. For all these reasons, Chapter 12 does not offend separation of power principles, because it provides the governor with the authority, and it provides the governor with the authority to make the necessary orders to carry out the provisions of Chapter 12. In our initial filing, we provided the decisions of the Stearns County District Court in the State v. Schiffler case, which was another enforcement action brought by the Attorney General's office against the bar restaurant in Stearns County that, similar to defendant here, was threatening to open in violation of the on-premises dining prohibition that previously existed in the summer. And in that case, again, these authority arguments were raised, and the district court recognized that the governor had the authority to issue the executive orders restricting on-premises dining pursuant to Chapter 12. With respect to defendants' the criminal sanction portion of defendants' separation of powers argument, really that argument is irrelevant to the case here today. The state has brought this case civilly and is seeking to enforce Executive Order 2099 civilly, not criminally. And so those arguments really have no bearing on the remedies the state is seeking to enforce here. In any event, this same argument was raised in the Schiffler case, as we note in our briefing, and rejected. And as we stated in our reply, even if the defendants prevailed on this argument, the correct remedy would be to strike the criminal penalties, not and that would have no bearing again on this case because it's a civil enforcement action. With respect then to the defendant's remaining constitutional arguments, which are equal protection and takings, the first thing the state would like to address is the fact that both of these claims need to be evaluated under, first and foremost, the Jacobson framework, which we provide in our opening memorandum. This framework has been applied by Minnesota courts, the 8th Circuit in Rutledge, and courts across the country when evaluating executive orders to issue that have been issued to protect public health and safety during the COVID pandemic. Under Jacobson, courts are to give significant deference to the emergency measures instituted during a public health crisis and should only find them unconstitutional if they have no real or substantial relationship to the object of protecting public health or safety, or beyond all question, a plain, palpable invasion of rights secured by the fundamental law. And Rutledge points out, Your Honor, the 8th Circuit decision that under the standards, courts are not to second guess the wisdom or efficacy of the policy choices states make in crafting emergency public health measures. So this is a deferential standard. And defendants come nowhere near meeting the threshold that needs to meet under Jacobson to show that Executive Order 2099 is unconstitutional. First, there's no dispute that Executive Order 2099 has a real and substantial relationship to protecting public health and safety from the community transmission of COVID-19. Moreover, defendant has not identified any fundamental right that has been plainly and palpably invaded beyond all question. And again, the same argument was made in the Schiffler case and rejected. The continued operation of a business, as the Schiffler court found, is not a constitutionally protected fundamental right, similar to, for example, the free exercise of religion. The Supreme Court has long held that the regulation of economic affairs does not infringe fundamental rights within the meaning of the 14th Amendment. And defendants appear to acknowledge this on page 9 of their brief. They note that economic regulations, when discussing their equal protection claim, are reviewed not under heightened or strict scrutiny because some suspect class or fundamental right is at issue here, but under the rational basis test. And where they state that in their brief, that portion of their brief is correct. The appropriate standard, even setting Jacobson aside for their equal protection claim, is the rational basis standard of review. Turning then to equal protection, and even if you put aside Jacobson, then the correct standard to apply, even under normal constitutional standards of review here, is the rational basis test. And that is the standard that was applied in the Schiffler case, as well as most recently in the Southwest School of Dance case as well, which the state attached as Exhibit 3 to my affidavit filed last night. Again, the court should find these decisions highly persuasive to its analysis here. Under the rational basis test, the state must show that Executive Order 2099's temporary restrictions on on-premises dining at bars, restaurants is a rational means of achieving the legitimate policy goal of slowing and preventing the spread of COVID-19. And actually, to correct that, the conduct of the state is presumed constitutional under this test. And in fact, the defendants must show that that's not the case, that it's not a rational means of achieving a legitimate policy goal. And I would direct the court to the Fletcher Properties Incorporated versus City of Minneapolis case. It's cited in our reply brief. It's 947 Northwest 2nd 1. This was a decision issued by the Minnesota Supreme Court in 2020 and does a really nice job of summarizing and explaining the current state of the rational basis test under Minnesota law. Here, the rational basis test has been easily met. There is no dispute that it is a legitimate policy goal of the state to slow and prevent the spread of COVID-19. And as already described, the governor's temporary restrictions on bars, restaurants are rational. The Department of Health, through its contact tracing efforts and analysis, has identified that bars and restaurants are one of the most high-risk settings in Minnesota for the easy transmission of COVID-19. And again, there's been at least 448 outbreaks at bars and restaurants in Minnesota, resulting in thousands of COVID-19 cases.
Mr. Plegencool, you know that that's one of the arguments that Mr. Tannick is raising on behalf of Boardwalk, is that it's not been, this isn't rational. If you can go to Walmart, you can go to other stores, you can go to the liquor store and other places like that. Why can't you also go to a restaurant? And I know you talked a little bit, your argument just here now about the rationality of that, but I think, you know, if you can speak specifically to those examples and the difference between those locations and a restaurant. What is your argument in that regard?
Absolutely, Your Honor. I can take some of them one by one. So with respect to retail settings, for example, these would be retail stores or convenience stores or grocery stores. The governor himself explains the rational basis in the executive order on page 3. He explains that these settings are lower risk based on the data he has from the Department of Health. He says, this is the quote from page 3 of the executive order: "We see relatively fewer outbreaks in retail settings, which generally involve brief, masked, transient interactions that pose lower transmission risk." And that's the reason for the difference, Your Honor. That is different than the risk posed, again, by sitting in a bar restaurant for a long period of time in close contact with others. You cannot be masked while you're eating and drinking. And so there is an increased risk in that setting that is not present in retail settings. And that's laid out in the executive order itself. With respect to some other establishments that the defendants mentioned are personal care establishments like tattoo parlors or salons. And again, the executive order itself explains the rational basis distinction between those and bars and restaurants. I can quote from page 3 of the order again. Outbreaks and cases traced to personal care establishments have also been minimal since those establishments reopened. Personal care typically involves one-on-one interactions as opposed to interactions with multiple persons, and healthcare-like precautions, like the requirement to wear a face shield over a face covering in many situations, reducing the need to restrict these settings during this dial back. So again, what MDH is seeing in the data from these other settings is different than what it's been seeing at bars and restaurants. And the risks are far greater based on everything, all the data and information that the governor has from the Department of Health, that bars and restaurants place a far greater risk to public health and safety than some of these other settings. With respect to the defendants also discuss Native American reservations. And again, as we pointed out in our brief, that argument was just recently rejected this week by the Ramsey County District Court, who noted that a sovereign nation that's entitled to self-determination under federal law is not similarly situated to bars, restaurants in the rest of Minnesota. And the governor's desire to respect the sovereignty of tribes to regulate the bars and restaurants over which they have jurisdiction he had a rational basis to distinguish them from other bar restaurants throughout the state.
What about restaurants at airports, Mr. Plegancool? There are different rules for those, and talk with me about that.
Sure. So that argument was also raised in the Schiffler case and rejected. So I would direct the court to the Schiffler case. And the difference for the treatment of bars and restaurants in airports and elsewhere is that as the Stearns County Court held, restaurants and bars located in secured zones of airports only serve patrons who lack the capacity to choose other restaurants. And I think we mentioned this in our reply brief that essentially these are travelers who are traveling potentially across the country and have limited options for food. They can't easily leave the airport in between connecting flights. And so they're not free to choose other dining options that the general public can. So there's a rational distinction between folks traveling that are behind the secured zone of airports and other bar restaurants. And again, even if the court disagreed with that rational distinction, the appropriate remedy here would be to strike that exemption from Executive Order 2099, not to invalidate the entirety of the order, as the defendants seem to seek. Your Honor, any other questions about?
No, you continue on your argument. I'm not sure if you had anything more to say on the equal protection matter, but
Sorry, Your Honor.
Go ahead.
One other point I did want to raise on equal protection is that the defendants are inappropriately, in the state's view, pointing to the recent Supreme Court's decision in the Archdiocese case to try to argue that heightened scrutiny, essentially strict scrutiny, because the court applied strict scrutiny in that case, should apply here. But that case is wholly distinguishable from the case at bar. The court applied strict scrutiny in the Archdiocese case because the fundamental right for freedom of religion was at issue in that case. In this case, there is no such fundamental right at issue. And so trying to morph what should be a rational basis analysis into strict scrutiny by citation to that case, which is wholly distinguishable from the facts we have here, the court should not entertain that and really should disregard that case. That this is not the correct standard to apply in this case. The last claim I want to address today is the takings claim. Kind of the first thing to point out is, again, this claim has already been brought repeatedly and rejected by Minnesota courts. It was rejected in the State v. Schiffler case, which did an extensive analysis. It was also rejected in the Bazell case, which I have attached as Exhibit 5 to the affidavit I filed last night. And again, the court should find these decisions highly persuasive to its analysis. The state was somewhat confused by what argument the defendants were making here. They seemed to, at times, state that this was a regulatory taking, and at other times state it was a categorical taking. First, it's clear that this is not a categorical taking. And that's because the defendant has not been denied all economically beneficial uses of its entire property. That's the standard for a categorical taking, and it's just not present here. Even the temporary restrictions that have been put in place, which again are just temporary, still permit takeout and to-go orders. And the executive order that's about to take effect will allow outdoor on-premises dining. And so again, there's no good faith argument that all economically beneficial use of the entire property has been taken here. So that where that leaves you is the regulatory taking analysis, which is under the Penn Central standard. And here, the dispositive factor of that three-factor test is the character of the governmental action. And the case that the state has cited in its reply brief that is helpful on that point, Your Honor, is the Zeman case, Zeman v. City of Minneapolis. And essentially what that case says is that when the health, safety, and morals of the general welfare would be promoted by prohibiting a particular contemplated use of land, courts will not find a taking. And the Zeman case says when the regulation at issue is a regulation to protect public health and safety, that third factor is the paramount factor the court must consider. Here, what Executive Order 2099 does is require that defendant temporarily not put their property to a dangerous use, which is on-premises dining, to protect the public health and safety. I don't think defendants dispute that the purpose of Executive Order 29 is to protect public health and safety. And under this well-established case law, that means there's no taking requiring just compensation. So for that reason, again, the takings analysis has been rejected by multiple Minnesota courts on that basis, and this court should do the same. So with respect to all three of defendants' constitutional claims, the state is likely to prevail on the merits of those. And as we've briefed, the state is all the other Dahlberg factors also favor the state here, which militate toward the court granting temporary injunctive relief in the state's favor. The last thing I'd like to say, Your Honor, is that the Attorney General's office, the state, takes no joy in having to bring an action like this. And the state understands it's a difficult time for businesses right now. But choosing to reopen for on-premises dining in violation of Executive Order 2099 is dangerous to the public health and safety, and it's unlawful. The purpose of Executive Order 2099 is to protect the public's health and safety, and the state respectfully requests that the court grant a temporary injunction to ensure that defendants comply in the future with Executive Order 2099 and soon to be effective Executive Order 20-103. And just one more point, Your Honor. I know you mentioned issuing or extending the TRO, and that's in the court's prerogative. I would just like to point out that the injunctive relief of the TRO presently in effect in effect, provides that, and I can read it to you. It's paragraph 3 on page 6. Defendant shall fully comply with Executive Order 2099 and any future executive orders issued by the governor, approved by the Executive Council, filed in the office of the Secretary of State in accordance with Minnesota Statutes Chapter 12 that apply to restaurants and or bars. And Executive Order 20-103 has been approved by the Executive Council and filed in the office of the Secretary of State. So I just wanted to point that out to your Honor.
And so you're pointing that out just as a way of saying that you don't think an order is necessary today, that based upon that language and also the language at the end on page 7, that this order remains in effect until further order of the court would be sufficient.
That's how I read the order, Your Honor. Yes.
Okay. All right. Now, there was an issue that Mr. Tannick raised about trial. Do you want to defer any argument on that until I've had given Mr. Tannick an opportunity to address the restraining order, injunctive relief, and his request?
I'm happy to address that now, Your Honor. The state opposes that request, and as we indicated in our reply brief, view it to be premature and inappropriate. The state does need to conduct discovery in this case to, among other things, determine the full scope of violations that existed here. There were numerous days when the defendant was operating in violation of Executive Order 2099. In addition, discovery is needed with respect to some of the remedies the state is seeking in the case, which include equitable remedies of restitution or disgorgement, as well as civil penalties. And the civil penalties are based on a 4-factor test under the Alpine Air Court of Appeals decision. And for example, one of those factors is the good or bad faith of the defendant. And so the state needs to do discovery before it would be prepared for trial in this matter.
Thank you for your argument, Mr. Plegancool. Mr. Tannick, before I turn to you for your argument, Mr. Plegancool's reading of the current order that was signed by Judge Harbit, with that language in paragraph 3 on page 6, as well as the language at the end of on paragraph 6 in the next page, that would be sufficient as far as, sorry, I just turned my volume up really loud. That would be sufficient. And his reading is of that order remains in place until I issue the next written order. Do you agree with that?
Well, we think the temporary, am I on?
You are.
Okay, thank you. We think the temporary restraining order, which is entered on an ex parte basis, should be dissolved as soon as possible. If you want to, Your Honor, enter an order to hold things in place pending your ultimate determination, that would, I think, probably be preferable to relying upon the ex parte order.
And I will turn to you for your argument here this afternoon. Go ahead, Mr. Tannick.
Thank you very much, ma'am. Please, the court and counsel. My name is Marshall Tannick. I am one of the attorneys representing Boardwalk Bar and Grill, along with Michael Vanslow, my colleague. I want to point out at the outset that we recognize, by we I'm referring to Boardwalk Bar and Grill, and counsel recognize the nature and severity of the current pandemic, the COVID affliction situation. We recognize it, we don't dispute it, we don't in any way minimize it. On a personal note, I have had clients, colleagues, friends, and close family members afflicted by this terrible disease. We are in no way minimizing it or indicating that it's not a real and serious problem. But an even graver problem is the deprivation of the rights of my client and other similarly situated institutions, bars and restaurants, who are suffering greatly under the governor's orders. Not only are they suffering great economic harm, but they're suffering a deprivation of their constitutional rights, which can and should be remedied by this court, consistent with the appropriate public health and safety needs of the community. As the court is aware from our briefings, and maybe personally, the facility here is a family-owned business. It's been in existence for about 11 and a half years, serves a large segment of the community in East Grand Forks. It is a restaurant, a bar, and an events center. There is significant competition right across the border in North Dakota, in Grand Forks. The facility is located in East Grand Forks, and right across the border is Grand Forks, North Dakota. Some 300 yards away, less than 3 blocks away from where my client's located, there's unrestricted access in North Dakota to bars and restaurants like this. We think that's significant insofar as it goes in large part to the balance of harm suffered by our client. We're not saying that necessarily Minnesota has to conform to North Dakota law or North Dakota law has to conform to Minnesota law. But I think the fact that we are dealing with a border town and a border facility has some different complexions and different considerations that come into play than perhaps a facility located, for instance, Brainerd or St. Cloud or even the Twin Cities where I reside. I think that ought to be taken into account, and I will point to that during the course of my arguments.
Let me ask you on that. Do you
Yes.
think that rises, I'm not sure if you're quite raising a Commerce Clause issue there or just in a more general way, kind of the issues, with the river and the close proximity between the two?
It's a good question, Your Honor, and I guess to use a phrase, it borders up against the Commerce Clause argument, but we are not making a constitutional Commerce Clause argument as such in this proceeding. I pointed out just to note that it has a significant impact on the burden and the onus that's visited upon Boardwalk Bar and Grill and plays a role in the analysis of the balancing of harm factor. So we're not saying that it's absolutely unconstitutional to do it because of North Dakota, but we are saying that it is that in looking at the situation and looking at the harm that's visited upon this facility, the fact that the competitors 300 yards away are able to engage in unrestricted business has a significant economic impact on this particular business. But it's a good question and one that I pondered at some length before putting together our argument for today. But there are devastating effects, Your Honor, here, pointed them out in our briefing. Some 20 employees have already lost their jobs. About 80% of the staff has been laid off. Obviously, they go into the large unemployment pool. They draw unemployment benefits, hopefully maybe an extension of unemployment benefits. They become drains on the state. Our business itself has suffered damages and loss of business. Since the first lockdown, approaching $250,000. That's $250,000. That's a lot of money for anybody, but it's a real lot of money for a small business. And more is in store. That's up to the time of this lockdown. And not only do the employees suffer here, but the business suffers insofar as it has this significant loss of income, probably puts it on the brink of going out of business. But the state suffers as well in terms of lost income taxes from the employees who aren't working, plus having to shell out unemployment benefit to those unemployed workers. And of course, the loss of sales tax and income tax revenue is harm to the state. It may be a drop in the bucket, but it's certainly a consideration that is reflective of the economic harm caused not only to the Boardwalk Bar and Grill and its owners and its employees, but to the state of Minnesota as well. And this is all exacerbated by the fact that being so close to the border, they're facing this intense competition that is thriving as a result of the lockdown here in Minnesota. The bar and grill that I represent, the Boardwalk, has since the initial lockdown way back in March when COVID first came upon us, has been abiding by all of the protocols. It has engaged in, it is abided by the capacity limits. It is engaged in strict masking requirements. It has engaged in social distancing. It has developed and implemented a COVID prevention plan. So it's done everything the right way. It's been a good corporate citizen. It's followed the rules. Some others have not. Some others haven't been under the rules. Some in Minnesota, as we know, have flaunted those rules. And indeed, as I pointed out, across the border, they haven't followed those rules because they haven't had those rules in place. So Boardwalk has been at a disadvantage in having to follow those rules, but it has followed those rules. And the continuation of this lockdown, though, threatens its very existence and that of its employees. We have a number of arguments that we've set forth before the court this morning. I will just briefly summarize them. I know the court had an opportunity to review our principal brief yesterday, and thank you for the kind comments about it, Your Honor. And it's a tough issue. There's no question about it. These are tough times, and it's a tough legal issue. I think the state's position is well briefed and well articulated, and we get it. And we're not saying that somehow the state is engaged in a bad faith or reckless effort, nor are we arguing in any way that the governor or those people enforcing the rules are venal or malicious. We all think that they're trying to do the best thing that they can do. So we're not impugning in any way the motives of the people the governor or anyone enforcing these regulations. What we are saying is that the court ought to take a real close look at the validity of this measure as it affects at least my client and inferentially others as well. One of the reasons that the governor's lockdown order, the executive order 2099, and it's now been extended, I think there's a different number to the one he entered the other day. The 2099 is the one that's issued today, Your Honor. And that lockdown order is, in our view, outside the purview of the governor's authority. And we briefed that, and I'm not going to reiterate our briefing, other than to point out the highlights are that the governor's authority to engage in the lockdown is set forth in the Emergency Management Act. That's Minstat Section 1231. It provides for it gives a 5-day period in which the governor can impose orders in an emergency situation, and it can be extended for 30 days with legislative approval, and thereafter for other periods of time with legislative approval. It's not my province to pass upon the quality of laws, but it's a pretty good law in that sense. It says the governor can act on an emergency basis for 5 days, and then the legislature can essentially confirm or ratify that action for another 30 days. And thereafter, if further restrictions are necessary, our government, meaning the governor and the legislature, must reach some agreement on what those restrictions, if any, ought to be. In this case, as is well known, Your Honor, there has been no legislative approval at all. The legislature has not approved what the governor has done. Now, that raises some political questions, but we're not here to talk politics. We're here to talk law. And the legal aspect of the legislature's inability or failure, if you will, to extend the governor's initial 5-day order is essentially puts the governor in a position of being essentially ultra virus. He lacks the authority to do what he's doing. The statute tells him what he can do. The statute sets out a fairly clear-cut blueprint of what he can do and when he can do it and what approval he has to have to do it. And he has not complied with that. There simply is no right under Minnesota law for the governor unilaterally to enter into these kind of orders without any kind of legislative approval. It can be called ultra vires, I guess, in the corporate sense, if this were a corporate law case, but it's not. As a matter of law or constitutional law, it's a blatant violation of separation of powers that should not be countenanced by this court or any court for that matter. So we maintain, Your Honor, as a threshold matter, because the governor lacks the statutory or other authority to enter into this lockdown at this point, at this time, it is invalid and not applicable to our client, Boardwalk Bar and Grill, and perhaps inferentially to anyone else otherwise as well. So as a threshold matter, we maintain that this court can and should decide the governor lacks authority. Therefore, the injunctive relief is not only inappropriate but unlawful. However, moving on beyond that, Your Honor, if the court were to conclude that there is authority for the governor to undertake this action, and we recognize that some courts have held that, there's been no binding authoritative decision by any of the Minnesota Court of Appeals or the Supreme Court. We recognize that there are some district court decisions. It doesn't mean they're right. They are what they are, and you can take them into account. Probably the closest case that's reached a tribunal, appellate tribunal, is the Wisconsin case. And although there are some different factors in the Wisconsin case that we point out in our brief, we cite the Wisconsin case. The Wisconsin case came to the recognition that the governor there lacked the authority to engage, to enter into a lockdown. There's some different statutes there, some different considerations, but the point is the court in the Wisconsin case focused on the authority, the basis for the gubernatorial authority, and came to the conclusion that the governor lacked that authority. We think this court can reach that same result, not under Wisconsin law, but under Minnesota law. So there is, if not precedent, at least some guidance that this court has to make that kind of determination of the lack of the governor's authority. However,
let me ask you a question in that regard about the authority piece. When I was taking a look at your brief, I think you had indicated and acknowledged that the governor has utilized peacetime emergency provisions that he's allowed to do, but where he overstepped that was by creating and or enforcing laws, and that should be something that is left to the legislature. But I guess my question to you is then what would the point be of having these peacetime emergency powers if there wasn't an ability then to enforce or create? And I know that Mr. Plegenkuhl's argument is, some of these penalties, like the criminal penalty, is not what we're talking about here. But generally, my question is, if he doesn't have the authority to put in some of those enforcement provisions, what good is having the emergency power?
Sure. First of all, there could be criminal implications here, because if an injunction is issued and someone violates the injunction, they could be subject to criminal contempt and other criminal proceedings as well. So I think it's a misnomer to say this case does not have any criminal implications, even though it's cast right now in a civil context. But to specifically address your good question, Your Honor, we point out that the governor has the authority to enter an order like this in peacetime emergency, which he did for 5 days. After that, he needs the legislative approval. The law requires legislative approval. It does not delegate to the executive branch sole, complete, and exclusive authority to make those decisions. So we're not saying that appropriate orders can't be entered nor enforced. What we are saying is that the legislature, by setting up the process in 1231, has provided a blueprint, a path for achieving that objective. The governor has strayed from that path. In fact, he took a few steps on the path and then jumped off the path and decided he'd build his own roadway. And that's what's improper here. So there's no question that if there is power to enter into an order, there's power to enforce it. But the question is, was there power to enter into this kind of extension without legislative approval?
Thank you.
And we maintain that the case can and should be resolved on that basis. However, if the court were to determine that the authority is present on the governor's part, notwithstanding the lack of legislative approval, then we do believe that the Dahlberg brothers test is the appropriate standard here. The state has asked you to dispense with the Dahlberg brothers analysis, which, as the court's aware, is the typical standard process for assessing and adjudicating injunctive relief. But the state maintains that because this action is brought under MnStat section 8.31, the Attorney General statute, that overrides or overcomes the Dahlberg factors. That's wrong, Your Honor. The state's argument is, simply put, is if the governor is doing something that is if the governor is acting pursuant to some kind of claimed authority, the court can't inquire into it at all. Well, that would result in the governor being able to do anything he wants under the pretense that he's enforcing some kind of law or some kind of order or some kind of protocol. But that's not the case. The case law under 831 that dispenses with the Dahlberg brothers, which is pretty rare, involves situations where the Attorney General is enforcing a particular consumer protection statute. That's the general thrust of those cases. In order to activate 8.31 as the measuring rod in this case, there has to be some underlying statute that the Attorney General is seeking to enforce. That's not the case here. The Attorney General is seeking to enforce a non-statutory executive order issued by the governor. And there's no case law that indicates that we're aware of that by virtue of the governor issuing some non-statutory order that's outside the bounds of a statute and not restricted by a statute, the court must accept that and essentially rubber stamp that without any Dahlberg Brothers analysis. The Dahlberg Brothers analysis is essentially a balancing test, a five-part balancing test, and it's the time-honored way to assess injunctive relief. We think it can and should be utilized here. Under those five factors in Dahlberg, the temporary restraining order should be dissolved, and the temporary injunction should be denied. As an initial matter, a pre-Dahlberg question is whether there is irreparable injury, and there is irreparable injury here, but the irreparable injury is imposed upon the Boardwalk Bar and Grill, which has been tottering and will totter probably out of business if it's not allowed to open for business, especially during this holiday time of the year. This is its most advantageous time to be open, the highest profitability time to be open, and without having the opportunity to be open through the holidays, it probably will, based upon its past history, not be able to survive at all. So there's irreparable harm. The harm is to the Boardwalk Bar and Grill, not necessarily the state. So that factor is satisfied here. The first of the other five factors under Dahlberg is the relationship of the parties. And in this case, there's been a good relationship. The Bar and Grill has existed for 11 and a half years. It's been a good corporate citizen. It's paid taxes, it's paid sales taxes, income taxes, employed lots of folks. And the state has benefited from that by having a facility serving customers. But more significantly, the state has benefited economically by the taxes paid by employees who earn an income, and by the business itself, which pays taxes and sales taxes. So the relationship is one that ought to be continued and allowed to thrive rather than to essentially dilute that business and put it out of business. The balance of harm we maintain weighs in favor of the Boardwalk Bar and Grill. We recognize that the very term balance suggests that there's considerations on both sides, and this isn't an open and shut easy case, as I've already indicated. But in balancing the relative hardships of the parties, we think that the weight of that balance comes in favor of denying injunctive relief. I've already pointed out the economic and other harm that the business will suffer, and it's not temporary harm, it's probably long-lasting and permanent harm. As far as the state, its alleged harm is much less. There's all kinds of other facilities that are allowed to be open. I'll get into that when we talk about equal protection, ranging from tattoo parlors to cafeterias, private cafeterias for that matter, restaurants, public restaurants, and airports, and so on and so forth. And the suggestion that somehow allowing this particular facility to remain open is going to cause serious and substantial harm in the state of Minnesota, I think, is highly exaggerated on the record here. Again, we do not minimize in any way the nature of the pandemic, the gravity of it, and the fact that there have been significant and numerous cases right here in Polk County. But we do say that the harm suffered by this business economically and otherwise, and to its employees, outweighs whatever minimal harm might occur, even if the bar is allowed to open. And we don't know what that is. It's pretty speculative. There's no indication in the record that the bar's operation in the past, the restaurant's operation in the past, has caused or created any particular specific harm to anybody. What's been presented to you is what we've all heard, read about for the last 9 months. There's possibilities that particular facilities are more prone, more risky than other facilities. We kind of know what they are. We know that people shouldn't group together, whether it's in a football stadium or in a movie theater or in any kind of public setting. We know that generally that's going to raise the risk of transmitting this disease compared to everybody staying home and no one going out of their house. But trying to make gradations between allowing people to go to Walmart and allowing people to go to beauty shops and tattoo parlors and the like and then comparing them to this one particular restaurant in East Grand Forks probably tilts the balance in the wrong way. This particular restaurant, which is the focus of this case, hasn't caused harm to anyone, and there's no indication that its being open would in any way extend further spreading of the disease.
If I'm hearing your argument correctly, then I know you know that the state has presented some scientific abstracts and research indicating that there's a greater transmission of COVID in a restaurant setting, and you believe that scientific information is not applicable to the boardwalk.
I'm not going to argue with science, Your Honor. We do note in our letter that we submitted to you earlier today, which you haven't had a chance to read, that it's a very short letter. We don't dispute science, but what we point out is that there are other more effective ways to deal with those claimed heightened risks. Probably the best way to deal with them is by capacity limitations, which the state has done in the past, with different gradations of how many people can be in a facility or not. But a complete lockdown across the board is not the most effective or rational way to deal with whatever perceived or actual scientific risks there are in people in a closed facility. That's why the CDC, in its recommendation from the outset, has recommended capacity limitations as an appropriate and suitable way to deal with increased risks of people being close together and assembling together and congregating in restaurants and bars. The CDC has taken that position since day one, that rather than a complete one-size-fits-all lockdown, a more effective way is to do capacity limits. And that's what the state was doing earlier. And this particular restaurant abided by that, up to the 50% capacity limit. And there's no indication that caused or created any harm. There's no indication that anyone has been afflicted because they've attended or been at this restaurant with a 50% capacity limit. Now, one can quarrel with, well, what should the capacity limits be? Should they be 50% or 60% or whatever? And that's not our province here as lawyers, nor your province, Judge, to make that determination. But the point is that there is a method in a way that can be done in a way that preserves the essence of the economic interest of the restaurant, along with protecting the public interest. We cite, Your Honor, in our brief this morning. I call it a brief. It's actually a short letter brief. Don't get too worried about it. It's only 2.5 pages of reading.
Okay, I just opened it up. I just saw it.
It's only 2.5 pages, so it is a brief.
Yes.
But we cite scientific academic authority from no less an institution in Northwestern University, which did a study along with my alma mater. I'll put a plug in for Stanford University. And those institutions have issued a study that focuses upon, that doesn't deny that restaurants and any other close assembly of people can create risks of spreading the disease, but it does focus on ways to minimize or halt that prospect, and capacity limits are the way to go according to those academic studies. So, as in most things, most things of a scientific nature, including the risk factors, are not without dispute. So, to answer your question, which I think I'm trying to do, but is that we don't dispute the science. We say there's other ways to deal with this scientific concerns, and academic institutions and scientific institutions have recognized that. And that kind of leads into the equal protection argument, the success on the merits factor under Dahlberg, and that's where equal protection comes in. So the third factor under Dahlberg, as the court's aware, is the success on the merits. It's considered the most important factor, but I find it in the various injunctive cases I'm in, on either side, it's often a difficult one to assess, because you're trying to predict essentially the outcome of a lawsuit, in this case, 1 week into the case, and like predicting the outcome of a football game after watching the first quarter, perhaps, of the football game. You don't know who's going to win or lose just by looking at the first quarter, but you have to at least make, the question isn't necessarily who is going to win, but is there a reasonable likelihood that injunctive relief will not be granted? That's the way I think to look at the likelihood of success in the merits. In fact, it's not an assurance of who's going to win, but it's a question of balancing likelihoods. In this case, there are at least two reasons in addition to the lack of authority, there are two constitutional reasons that we've put before the court why we think that the boardwalk has a likelihood, not an assurance, obviously, but a reasonable likelihood of being able to prevail in this case, depending upon how the facts and issues ultimately turn out in full-blown litigation. The equal protection argument is the most important argument, we believe, and one that ought to be given serious attention. We point out that the standard is the rational basis test here. It's an economic regulation. It's not subject to strict scrutiny, but even under the rational basis test, which, as we all know, is pretty relaxed, a pretty relaxed standard. Nevertheless, if one takes a close look at this, rather than just kind of looking at it from 50,000 feet, so to speak, there are real serious deficiencies in the reasonableness or rationality of this order. A flat out, everybody has to close regardless of where you are, regardless of your size, regardless of your ability to conform to these other protocols of social distancing and masking and capacity limits. It's almost inexplicable. Well, it's explicable, I guess. Anyone can explain anything, but it's inexplicable rationally to distinguish between tattoo parlors and beauty salons, which are allowed to be open, and this restaurant, which isn't. Now, I know the state has said, well, the difference is the difference between a Walmart, for instance, and a restaurant is in a restaurant, people are sitting together for an extended period of time, and they don't have the masks on while they're eating and drinking. Whereas in Walmart, you're kind of walking through aisles and you're not in close contact with the same people all that time, and you have your mask on. And that's true. And that's true. There's some differences, but nevertheless, there are some similarities as well. It is the case that people oftentimes will be grouping together and congregating together with other people at a retail facility like Walmart. I was in my local Costco the other day, and I was standing in line there for 40 minutes. I timed it, and I was next to a lot of people during those 40 minutes. There was a lot of close contact in retail facilities, as there is in restaurants as well. You can even be closer to people for a longer period of time when you're in a retail establishment as you are in a restaurant. But that's just the retail stores. There's also the current lockdown does not apply to these other facilities like tattoo shops and beauty shops and so on and so forth, where there's immediate close contact between people for a long period of time. And even if they have masks on during that period of time, that doesn't solve the problem of close social relationships. So being in a restaurant with 4 people at a table with social distancing, with other appropriate protocols, can be safer than being face to face within five inches of someone giving you a tattoo or a beauty salon. So those kind of differences are really not rational. But there's even a greater reason why, the more significant reason why the rational basis test fails here, and that's because other restaurants are allowed to be open under the governor's order. You mentioned that before, Your Honor, and I just want to address that for a moment. The governor's order allows restaurants at airports to be open. We've heard the argument about why that should be, because travelers can't get out of the airport when they're changing planes, and therefore they have to be allowed to eat on premises so they have someplace to eat. Well, maybe so, maybe not. Travelers could bring their own food if they're just making a stopover and changing planes. They can bring their own food. They don't have to eat at a restaurant. Firstly, secondly, the having restaurants open at airports isn't limited to travelers changing planes. That applies to people who are coming to an airport to get on a plane. It applies to people who are arriving here at their destination and going home. It applies to people who are with travelers, guests, visitors. It applies to anybody. So under the governor's order, people can go eat at restaurants and drink at bars if they're in airport facilities. That makes no sense from a rational basis standpoint compared to the boardwalk, which has these significant protocols in effect. It's not just airports. Also, the governor's order doesn't extend to restaurants and reservations. And indeed, the governor does have, the state has authority to make that kind of regulation if it wants. I know the argument is made, Your Honor, that, well, because of the sovereign immunity, the state can't affect reservation business. That's not so, Your Honor. The state does have authority over certain activities that occur on an Indian reservation, notwithstanding sovereign immunity. The State v. Thompson case is notable. That's a Supreme Court case from this year in which the authority of the state over reservation activities. Now, that was a criminal law case, but the authority of the state over activities that occur on a reservation was recognized in State v. Thompson. It's a Minnesota Supreme Court case. It's number 18-0545. I don't think we cited it, so I'll give you the number 18-0545. I believe the site is 937 Northwest 2nd 418. It was decided in January of this year, and it stood for the proposition that the state's authority over criminal DUIs extend to reservation activities. Granted, it's different than this case, but it stands for the proposition that the state does not have to honor or recognize sovereign immunity when it is engaged in activity for health and safety purposes. So by the same token, the governor could have, in this case, extended that that restriction to reservations. He didn't. So there's another place where people can go eat and drink and cavort without any restrictions, as they can in airports, and there's more. This law does not apply to school cafeterias. Now, we know some schools are open, some aren't, remote learning, hybrids, and all that, but nevertheless, there's eating that goes on in schools, in school cafeterias. It may be somewhat of a lesser issue here with the holidays coming on and school being out for the holidays, but nonetheless, food can be served and eaten in school cafeterias. If the risks were so high for people gathering together to eat in facilities, then school cafeterias ought to be on the governor's list, but they're not. And yet another deviation from a rational classification. Furthermore, there are large businesses, mainly, although some smaller ones perhaps too, that have private cafeterias on premises. Many of the larger companies do have private cafeterias. General Mills, I know, does. Many of the Fortune 500 companies, and even insurance companies and others, have cafeterias right in their premises, as do some government buildings as well. But those restaurants are not restricted in those areas. So here we have kind of a patchwork of not only are there irrational distinctions between types of businesses, restaurants versus tattoo parlors versus beauty salons and retail shops, but there's also internal inconsistency and irrationality in allowing some restaurants to be open and then not allowing others to be open. I think these issues are heightened, Your Honor, by the Supreme Court decision in the Roman Catholic Archdiocese case versus Cuomo. Both sides cited. There's been a fair amount of discussion about that in the last couple of weeks in the regular media. We recognize, of course, that was a First Amendment religious freedom case. This one isn't. Say what you will about restaurants and bars, but it doesn't have any religious connotations that I'm aware of. So we're not arguing that there's some religious freedom here involved, but we point to that case because in that case, the gravamen of that case wasn't just a religious freedom case. The court recognized the inconsistencies and irrationalities in the classifications by the the governor of New York. The restrictions were irrational because some places that could be open posed as greater risk as those that were restricted. So the fact that it came up in a religious context, nevertheless, it wasn't based solely on classic First Amendment religious freedom issues. It was based upon selectivity within religious institutions versus non-religious institutions. Or put another way, it's the equal component. It's the equal protection component of the First Amendment. By treating similar institutions differently and treating different institutions similarly, the restrictions in that case violated any rational basis. And that was pointed out in the concurrence, in particular, by Justices Kavanaugh and Gorsuch. The key phrase that emerges out of that case and really provides the underlying rationale for the decision, because it was the decision was the fact that the restrictions in the New York case were not, quote, narrowly tailored. There was a broad bus approach. It was overbroad. It was over-inclusive. And what the court said there is the restrictions in that case were constitutionally infirm, not solely because they affected religious institutions, but because they were not narrowly tailored in a way that took into account lesser alternatives. And that's true. That's true in our case as well, Your Honor. There are a number of lesser alternatives that can address the real and serious and substantial public health problems posed by COVID. One of those is one we've already mentioned, having some kind of capacity limits, which is predicated upon not only what the CDC, Center for Disease Control, has done, but also these academic studies that are cited in our reply brief today. Having those.
Let me ask you a question about that, because I would imagine the state, or at least the questions that I have when we're talking about this is, while there may be other options that are different and that Boardwalk would prefer, isn't it the burden on Boardwalk to prove that the gradations or differences that are in place right now are not rationally related to a legitimate government purpose? And so it's not that there might be better or alternative provisions or one that would be more tolerable to Boardwalk. It's, we have these differences in place right now. Are they or are they not rationally related to a legitimate government purpose?
Right, and as I've indicated just a few moments ago, they aren't rationally related, because you have some restaurants are allowed to be open with no restrictions. Other restaurants are not allowed to be open and are subject to total restrictions.
But aren't you asking me to consider the same thing, that gradations of allowing 25% occupancy, allowing these different things are kind of the same example?
No, what we're saying, Your Honor, is that there is no rational basis for this particular order the way it's structured. It allows retailers and retail box stores and any retail business to be open. It allows tattoo parlors and beauty salons to be open. It doesn't allow restaurants to be open. That's one type of irrationality. But a more serious one is that this executive order allows restaurants to be open at airports and schools and private cafeterias and the like, without allowing restaurants to be open, like my client. There's no rational basis for making that distinction. So we're pointing out that the governor here has created an irrational patchwork that does not make sense. Then we say, because it's irrational, one looks to other alternatives. Are there other alternatives? Can this be more narrowly tailored? And we say that it can be, because the scientific and academic authorities recognize that there's another way to do this without making that kind of irrational distinction, and that's through some kind of capacity limits. Indeed, the council quoted from the governor in his presentation, and I'm going to quote from the governor too, but I'm just going to quote two words from the governor. In announcing the extension of the lockdown, which is at issue here, the governor said this is, quote, not fair, unquote. Well, that's right. And that's the epitome. That's a quintessential recognition of an equal protection problem. That's really what equal protection is all about, fairness. And we recognize perfection isn't the goal here, but at least treating similarly situated institutions similarly requires some degree of fairness. The governor himself has said it's not fair. So
let me push you on that just a little bit, because
Sure.
That's not the legal standard. The legal standard is what is not what's fair for me to consider under equal protection. Is there rational basis? It's not is this fair? I think we would all agree that this situation is unfair to everyone in varying degrees, but that's not the legal analysis.
Well, no, I mean, the legal standard isn't fairness, but
Right.
but rationality as a component of being rational is being fair. If something is admittedly unfair, then one looks at whether it's rational or not. If you say I'm setting up a system here that's not fair, that connotes that there's some irrationality in the process. So the governor's recognition that this is not fair is, I think, a telling admission. It's not conclusive, it's not determinative, but it's suggestive that the lockdown restriction deviates from a rational edict that separates institutions on a rational basis. To say something's not fair means it's not rational, because it can't be rational if it's unfair. So while we're not saying the legal standard is fair or unfair, because that's not your job to decide, we are saying that when an institution promulgates a rule and states that the rule is not fair, that raises some real red flags as to whether the rule is rational or not, and we maintain it's not. There's a second reason why the boardwalk has a likelihood of prevailing, and that's the due process. That's the due process argument. It's contained in our legal brief. I don't want to dwell on it too much, but essentially, this is a deprivation of property, which is income, to this institution, and the government can't take away someone's income without having simply on a rubric of public health and safety. If that were the case, there'd be no need for the Fifth Amendment and the Due Process Clause. In this case, in cases like it, when the government shuts down a business, it effectively takes away that business's economic base. And when it does that, there's a violation of due process. So we maintain that there's a legitimate and viable due process claim here, and that adds to the likelihood of the boardwalk being prevailing on the merits of this case. There are two other considerations that come under the Dahlberg Brothers standard. One's the public interest. I've addressed that before. The public has an interest in keeping people employed, allowing them to thrive, allowing them to be economically sufficient. And the state has an interest in that as well. There's a public interest in seeing that the businesses like the boardwalk don't go under. There's a public interest in seeing that they can derive revenue to pay sales taxes and to pay income taxes. The state actually benefits from this facility being open, so the public interest cuts in favor of denial of injunctive relief. The governor has, as we all know, as of I think it was yesterday, announced the extension of the lockdown through the early part of January, but he has allowed restaurants, including the boardwalk, to function outdoors. Well, thank you very much, but that doesn't help here very much in Minnesota. I think it's a matter of judicial notice that it gets real cold in Minnesota in late December and early January. And that might be a good alternative, talking about less restrictive alternatives, Your Honor. That might be an appropriate alternative if we were in Arizona or Florida, but we're not. And allowing businesses, restaurants like the boardwalk, to remain open for outside dining is just, it's illusory. And in fact, it might even be more detrimental to public health. Having people sitting outside shivering in temperatures well below freezing and perhaps even plunging to at or below zero if that comes up. So that doesn't salvage this lockdown order. Lastly, Your Honor, the last Dahlberg Brothers factor is administrative feasibility. In this case, a denial of imposing injunctive relief would not be that. It would pose some administrative problems here. One would have to, from time to time, patrol that, see if there's compliance with the directive or not, try to put out whatever fires occur, and it creates some burdens for the court and for everybody else. However, denying injunctive relief with the caveat that this business continues to abide by all appropriate protocols as it has in the past, social distancing, masking, capacity limits, and preventive nature matters of that kind would not pose any administrative burdens on anybody, and would facilitate a smooth operation of this business. So we maintain, Your Honor, the Dahlberg factors by and large cut in favor of the boardwalk in this case and warrant denial of injunctive relief. In summary, Your Honor, we think that the governor lacks authority to enter in to make this order, and we think that the balance of factors under Dahlberg, if applicable, cut against injunctive relief. We would ask, therefore, that the court dissolve the temporary restraining order, deny the injunction, and dismiss the lawsuit. Thank you.
Thank you, Mr. Tannick. I'll just say I'm going to ask Mr. Plegancool if he has anything further he wants to argue today. I'm getting some background noise on your end. I don't know where it's coming from, but if you...
I will stop it.
Okay, thank you. I'm just going to take a break here until he comes back, Mr. Plegancool.
Excuse me, Your Honor. There is another legal proceeding going on at this remote facility.
Yes, thank you. All right, Mr. Plegancool, you've heard Mr. Tannick's argument. Do you have any summary argument in response? Go ahead.
Thank you, Your Honor. Yeah, I do have a few things. First, I was pleased to hear Mr. Tannick state that the rational basis test does apply to the defendant's equal protection claim. That the state agrees with that. The rational basis test is the correct standard. And for that reason, the court should really, once it has a chance to review the letter filed this morning by the defendants, should really disregard that letter. It's arguing for, less restrictive means, narrowly tailored different restrictions that are strict scrutiny arguments that are inapplicable to the rational basis test. And so, again, the Archdiocese case applied strict scrutiny because that was a First Amendment free exercise of religion case and is completely distinguishable from the case at bar. And really what the defendants are arguing for is not only the wrong standard, but exactly what the Rutledge case instructs courts should not do in these circumstances. They're asking this court to second guess the wisdom and efficacy of public health emergency measures that the governor has put in place to deal with the global pandemic. And that is not the function of the court. As the court noted, what your role is to determine is Executive Order 2099's restrictions on bars and restaurants rationally related to a legitimate public purpose. And, I don't think there's disagreement on the public purpose. And with respect to rationally related, I would again point the court to the Fletcher decision that was recently issued by the Minnesota Supreme Court. Again, that's 947 Northwest 2nd 1. And for example, at page 29 through, I believe, 30, near the end of the opinion, the court talks about over-inclusive and under-inclusive and states that under the rational basis test, legislation does not need to be perfect. And, quote, when the basic classification is rationally based, uneven effects upon particular groups within a class are ordinarily of no constitutional concern. The calculus of effects, the manner in which a particular law reverberates in society is a legislative and not a judicial responsibility. Again, Your Honor, Executive Order 2099's restrictions are rational, and that is the extent of the court needs to engage in with respect to analysis here. Obviously, the defendant believes there should be different policy choices made here, that they think there are better policy choices. Those are legislative questions that the governor, in consultation with his experts at the Minnesota Department of Health, has had to make. They're difficult decisions, no doubt, during this pandemic, but they are rational and they're supported by the best evidence that the Minnesota Department of Health can provide the governor on a daily basis. And so for all those reasons, the state, and for all the reasons stated in our briefing, the state respectfully requests that the court enter a temporary injunction in this matter, requiring Boardwalk to abide by these emergency health restrictions that are in place to protect public health and safety. Thank you.
Mr. Tannick, any last words tonight? This afternoon, I should say.
Council said that these are legislative decisions, but the legislature hasn't weighed in at all. The statute requires the legislature to be involved in any kind of decisions beyond the first 5 days, and certainly beyond the first 35 days, relative to imposition of any kind of directives under the Emergency Management Act. The legislature hasn't been involved. That's why we maintain that the governor lacks authority here. So the contention that these are legislative decisions is correct, but haven't occurred here, and that's why the governor's order is invalid. Thanks for your time, Your Honor.
Council, thank you very much again for your briefing and your very articulate argument today.
So for now, that restraining order against the Boardwalk Bar and Grill, prohibiting them from doing indoor dining and beverage service, remains in effect as we wait for Judge Rasmussen's order. We'll try to get that for you as soon as it's available. I'm Neil Carlson reporting for iNewZ.TV.